everyone, and welcome. I'm Michael Green, the Clerk of Green's List, and I've got no real official function here this morning, but I thought I'd like to bring to your attention a flyer that's in the folder there for a new business called Ethics for Lawyers. That's a business started by Michael Dolan here on my left and his business partner Donna Cooper. Michael and Donna were a part of the LIV's ethics department, and over the last 2 or 3 months they have boutique law firm for lawyers, as it says here. I'm very happy to be able to tell you about it because Michael and Donna have been very good friends of ours here with our Green's List seminars. They have both chaired seminars for us, they have spoken, and their knowledge of the ethics of facing lawyers, or ethical questions facing lawyers, and their common sense and their approach to things, I think, is something which recommends them very highly to everybody who may have an ethical question. It's a more complex professional life, as we all know, and so it seems to me to be appropriate that there be a business that is A, ethics for lawyers, and B, on the sides of lawyers. I've always thought we as lawyers need a strong advocate on our side, and that's what Michael and Donna provide, Ethics for Lawyers. So please welcome Michael Dolan.
Thank you very much, Michael, for that very kind welcome and those few words, and thank you very much for inviting me to chair this morning's session, and good morning, ladies and gentlemen. I'd like to begin by acknowledging the traditional owners of the land upon which we meet, and I pay my respects to their elders, both past and present. We're very fortunate to have as our presenter today a good friend of mine, Brind Zichy-Woinarski QC, who I'm sure needs very little introduction from me. Brind and I were admitted to practice a month apart a little while ago. Like 2 bottles of excellent red wine, I believe we behaved very well, Brind. That's what we're saying.
I've probably been in the bottle too long.
So Brind is a leading Queen's Counsel with extensive experience in all aspects of criminal law advocacy, both defending and prosecuting, both at trial and appellate level. And importantly for our session this morning, Brind chaired the Vic Bar Ethics Committee between 1993 and 1999 as a regular presenter on ethics issues. And I've put here that he's passionate about ethics because he and I have discussed this subject on a number of occasions. So he's going to guide us through the ethical responsibilities and pitfalls of lawyers being involved with technology and social media. So thank you, Brind.
Thank you, Michael. Can I just join with Michael Green in congratulating Michael on starting up Ethics for Lawyers. It's got a figure 4, not the word for between the 2 words, consistent with the digital age in which we live. But I think it is really a great step that we now have a firm specialising in legal ethics here. Because we're dealing with technology today, I've taken the obvious step of ensuring that I won't use any technology. I'd prefer you all to listen for a change. Now, many of us have grown up using devices such as these. Many of us did not, and as I look around the room, I can see that quite a few of you fall into my category of having, as I said before, been in the bottle for far too long. Whatever category you fall into, they have become part of our everyday life, and we can't do anything about that. We live in an electronic age. The notes for this talk were created electronically from dictation to final printing. We send each other SMSs, emails, exchange documents by attaching them to emails, leaving them on the cloud, Dropbox, or some similar medium. We communicate with colleagues, friends, acquaintances, and often many other people unknown by various electronic forms, including social media such as LinkedIn, Facebook, Instagram, to name but 3. Technology, of course, does not simply encompass social media. Social media is but one aspect of technology. And I'm sure some of you have thought about this, but I'm not sure whether all of you have. It opens up a minefield of potential problems. Now, before I go to some of those problems, I think it's helpful just to consider why this has come about. Technology has changed our way of communicating enormously. Until, particularly since the mid-1990s, with the rise of the internet. Before then, we communicated by telephone, landlines, mainly, although mobiles or cell phones were becoming popular towards the end of the 20th century, we used faxes and letters for written communications. Emails were relatively rare until the last few years of the 20th century. And some people, even to this day, still handwrite their communications, but with increasing rarity. So until the late 20th century, perhaps with the exception of phone calls, unless they were recorded, which happened very rarely, communications were in a form that was relatively stable, could be seen, could be looked at, and had an actual physical three-dimensional presence that remained even once filed away. Now today many lawyers have grown up, they've had their whole education in an era when electronic communications dominate, whatever form. Such communications appear on the screen of your device, you press the delete button and it's gone. Or more correctly, you may think it's gone from the memory, but it's often still there to be recovered both by non-experts and experts. Now, such communications, unless printed, have never had a real physical presence on a piece of paper. You don't need to pick those sorts of communications up and use your own energy to destroy them, such as tearing them up, burning them, or even throwing them in the waste paper basket. So consciously or subconsciously, I think, we seem to regard electronic communications as almost ephemeral, here for a brief period of time and then gone forever. It's just not so, as many have found out to their displeasure and detriment. An example, when I and my friends used to arrange to go out for dinner, we did it by telephone. Today it's done by SMS or some form of social media. Many studies have shown that those under 30, and I'm not trying to pick on any age group or demographics, but those under 30 use phones far less for making phone calls than they do for communicating by way of chats, social media, or whatever it is. And in fact, some of the studies show the actual phone usage for those under 30s is no more than about 20% of the usage. The reality is that these apparently ephemeral electronic communications are creating a vast record of your life and your views, and that's a record which is very difficult, if not impossible, to erase. Okay, so let me just turn to some practical considerations of technology. And before I do that, I just want to highlight some of the provisions of the Uniform Conduct Rules for solicitors. There are similar rules for barristers. 3.1, the paramount duty to the court. 4.1.1, to act in the best interests of the client at all times. Rule 9, dealing generally with confidentiality, and by that term I include both information that's subject, or communications that are subject to legal professional privilege, and also confidential information gleaned from the client. Rule 31, inadvertent disclosure of confidential material by another solicitor. And Rule 33, communicating with another solicitor's clients. Now, technology, as we know, is encroaching on even the way we do discovery. Documents are in electronic form. They can be easily searched, identified, to identify those that need to be discovered, downloaded to a disk, a thumb drive or something like that, and then examined to see whether or not any of them should be subject to a claim for privilege. We use search words or algorithms to do that. Inevitably, those algorithms or search words are not going to pick up all the relevant documents. They might fail to pick up a document which you should actually claim privilege for. This is going to happen. It will become less frequent, but it will continue to happen because, one, the volume of documents that are in electronic form, and two, how good or how bad your algorithm or search terms are. Now, experience does tell us that despite our best endeavours, some documents that should be subject to a claim for LPP get through the net. And I just want to take you to a case that relates to that and then lead on to some of the consequences that flow from that. Now, there's a High Court decision in Expense Reduction Analysts Group and Armstrong Strategic Management and Marketing. It's 2013, 256 Commonwealth Law Reports 303, where the High Court considered just a situation. Litigation being conducted under the New South Wales Civil Procedure Act 2005, which is really the same as our Act. Some 60,000 documents needed to be reviewed by the appellant in the High Court, who was the A defendant below. Privilege was claimed appropriately, and upon inspecting the discovered documents, the solicitors for the respondents noted what appeared to be privileged documents. They wrote to the solicitors for the appellant, advising them of that. The appellant's solicitors wrote advising the documents had been inadvertently discovered, sought their return, together with an undertaking that the documents not be used or relied upon. The respondent's solicitors replied basically, get stuffed. Proceedings were brought to restrain the respondent from using the documents and for their return. Now, at first instance, relief was generally granted. The New South Wales Court of Appeal reversed the decision, and the High Court restored the original decision at first instance. What's apparent from the High Court decision is that each case will depend upon its own factual circumstances. Now, in expense reduction, there was no dispute that there'd been a mistake in discovering the documents, and that led the High Court to be very critical of the conduct for the solicitors for the respondent. They'd wasted much court time in acting as they had in respect of the mistake. They had acted in a way that was inconsistent with the Civil Procedure Act. And thirdly, they'd ignored the effect of that rule that I mentioned earlier, Rule 31, which deals with inadvertent disclosure. Now, I just want to quote a few passages from the High Court and then move on. Quote, what the court was faced with was a mistake which had occurred in the course of discovery. It was necessary the mistake be corrected and the parties continue with their preparation for trial. And about what is now Rule 31, such a rule should not be necessary. In the not too distant past, it was understood that acting in this way obviates unnecessary and costly interlocutory applications. It's an example of professional ethical obligations of legal practitioners supporting the objectives of the proper administration of justice. Now, each of those criticisms by the High Court, and there are quite a number of others, raised possible disciplinary breaches by the respondent's solicitors. That well-known legal publication, Lawyers Weekly, said of the High Court's decision, and I quote, that it had found Mark Lawyer's managing partner, Michael Bradley, act in a way that flies in the face of a lawyer's ethical obligations. Now, I'm sure none of you would want such publicity. I can, however, add this to you, that I have done searches and I've not been able to find anything to suggest Bradley or his firm was in fact charged with unethical behaviour. Now, in the Court of Appeal, I just need to go back to the Court of Appeal. The view had prevailed, although rejected by the High Court because of the actual circumstances, that the sending of the documents was an intentional act by the appellant's solicitors, carried out with the knowledge that privileged documents can be withheld from production. That act was done in the course of court-ordered discovery, where the list of documents was verified and certified, and there was a time lapse and the mistake was not obvious. Little hard to understand the last comment given the fact that the respondent solicitors identified it when they inspected the documents. Now, I want to turn to practical problems flowing from that decision. Rule 4.1, just let me remind you, you've got to act in the best interests of a client to deliver legal services competently. Rule 9, confidentiality, and as I've said, that includes both LPP and confidential information. And Rule 31, inadvertent disclosure. Let's go to the innocent email. Let's take a real-life example where you're not starting an email string, but simply, as often happens, continuing it. The email string, by the time you get it, may have been sent or copied to many people. The client may well have forwarded an earlier non-privileged part of the string to someone who cannot claim common privilege. It's this chain of addressees that becomes the real problem, simply because of one thing on your computer: reply all. That's the problem. Emails between firms of solicitors on either side of litigation are far too frequently sent as reply all correspondence. Often one has no idea of the identity of many of the recipients because their names don't even appear as such, but there's simply a total number of recipients. Often you'll have plus 31, plus 121. You click on that, are you really going to go through those 121 or 200 people or however many it is? Of course you're not. You haven't got time to. It's very easy then to send an email containing or attaching a confidential communication, privileged or otherwise, to a large number of people using the reply all button, resulting in the potential disclosure of confidential information, let alone privileged communication, to the other side or to a person who doesn't have the common privilege. Naturally, your immediate response, having regard to the case I've already taken to you, is it was a mistake, it was inadvertent. Now that may well be so, but I take the view that inadvertence is not going to get you out of this problem. By pressing the reply to all, you have consciously decided that all persons named as addressees or copied in are to receive the communication and any attachment to it. It may then be difficult, and I think it's probably impossible, to argue that the disclosure was inadvertent or mistaken. You intended to send the email to all those people because you chose reply all. That was a conscious decision, a conscious choice. And the example I've just given is very different to expense reduction. There the mistake related to failing to identify all the privileged documents in the discovery process in which privilege had been claimed with respect to some of them. In my example, there's a conscious decision to include the privileged communication and the deliberate decision to send it to all. And further, that usual caveat disclaimer clause at the bottom of your signature line to the effect that if you've got it by mistake, please destroy it, send it back or something like that, is unlikely to help similarly, because how can it be said that the recipient received the email by mistake? It was your choice to send it to them. Now, it's not difficult to see how such an email, even assuming that its ultimate privilege is not lost, could be said to be in breach of one's duty to a client and thus a potential breach of your ethical duties. So remove reply all and instead do what we used to do years ago, which was we dictated a letter and it had somebody it was being sent to, and at the bottom you would dictate copy to, and you'd see at the bottom of the letter CC'd and a list of people. Choose to whom you are going to reply. Don't press reply all. And indeed, I go further. I simply say, take it out of your system. Get rid of it. Throw it away. Remove it. You don't need it. It's a real nitrogen bomb, hydrogen bomb waiting to blow up in your face. Now, it's not only you, it's your clients who've got the same problem, because they do the same thing. And as I've identified, that may be part of the problem which causes you the problem. So the clients need to be warned of exactly the same problem and instructed, you can't make them, I know, but instructed to think about this very, very seriously. And it may be, even if not today, it may be that failure to warn your clients about such things may be a failure to properly advise them about such dangers, and that could give rise to ethical issues. And it's not just your lawyers, it's not just your clients, it's the staff as well, because they equally can make the mistake on your behalf. So, as I say, get rid of it. Now, whilst on emails and the need to protect confidentiality for clients, I think we all need to give serious consideration now to using encryption of some form for all email communications, at least those that have confidential, are confidential. You cannot ignore the fact that technology has opened the doors to hacking, and cyber security is something that not only needs to be considered but put in place. And encryption is simply one form of cyber security. Social media. I mentioned three popular forms of the media: LinkedIn, Facebook and Instagram, but that's not all. There's a lot of others. I also include LinkedIn groups, for example. Social media also includes Twitter, blog, content sharing sites, apps, and I emphasise this one in particular, professional networks. Now, the Law Institute has published guidelines on, and I'll give you its title, Ethical Use of Social Media. The Office of the Legal Services Commissioner has published both a practice note and a guide on practical issues social media. They're available online, and if you haven't looked at them, I strongly advise you to do so in the very near future. The LIV guidelines make reference to the following potential pitfalls. Some of them you might think are obvious, some of them you mightn't have thought about. Confidentiality, I've discussed that. Inadvertent retainer. Have a think about that one. Administration of justice, breach of the no contact rule, Rule 31 that I've already referred to, and they also identify other risk areas such as defamation. Now, I'm not aware of any Australian cases that deal directly with the ethical obligations of lawyers and their interaction with social media, and that's probably because they're yet to occur or they're in the pipeline. However, social media has already assisted in the prosecution of a second-year law student for engaging in legal practice when not qualified to do so, and in fact on 6 separate occasions. In August 2014, he pleaded guilty to all the charges. On 3 occasions, the student had represented himself to be a lawyer at a Gold Coast law firm when he'd appeared before 3 different magistrates in criminal matters. He'd also sent an email seeking an adjournment, which he'd signed claiming to be a solicitor, and a couple of other similar acts. He had in fact been working for a Queensland barrister as a law clerk, and it was the barrister who initially revealed the truth of the situation to a magistrate. But an examination by the prosecution of the student's social media account revealed that he had posted screen grabs of himself acting in a legal capacity on Channel 9 News, on Facebook and LinkedIn. and the posts had been accompanied by very imaginative hashtags: lawyer, young lawyer, criminal lawyer. Now that may be on one view an extreme example, but it does demonstrate the need to be careful. And it also demonstrates something else which I want to touch upon, and I'll do now, which is such posts can come back to haunt you many years later, because you think they've gone, you take them down, they haven't, they're up there, they're on somebody's server, or, and this is of course what he had done which got himself into trouble, somebody has taken a screenshot of the post and kept it themselves. Now it's very easy to take a screenshot of something that's on your computer screen. And it's very easy then for you to circulate that, for whatever reason, to the world at large. And it's happened time and time again. So the fact that you put something up and you take it down, don't think that it's not up there on somebody else's memory and they're going to use it perhaps innocently, but to your detriment. And you've got no control over how they use or disseminate screenshots. That simply is another example of why you have to be very careful about what you post anywhere on the internet, be it social media, an app or anything like that. So do your clients. Your clients need to know these things. I'm told by colleagues that social media posts, and particularly screenshots of them, are now commonly part of the evidence in the magistrates' court in apprehended violence applications. They're there. It's not a matter of word against word. They're physically presented to the magistrates. And I've heard from some magistrates that they wish things like Facebook and LinkedIn would just, Facebook in particular as I understand, would just disappear. People would get rid of it. That may happen for obvious reasons. So that's screenshots. They're dangerous. And the reason they're dangerous is because you've put something up there that may come back to cause a problem. Let's turn to the courts a bit. In America, judges have been barred from sitting on cases because they were friends on Facebook with one of the attorneys retained in a case to be heard before them. There have been other cases which have resulted in a differing view. There's quite a wide range of views in America. Some of them, the very extreme, are that you only have to be a Facebook friend even though it's only been done to increase your number of friends so it looks like you've got hundreds of friends when you've really only got 3. That's sufficient. And there are other cases that say, no, it's got to be a bit more than that. The United States has a wonderful case of Pashek, and that's a good example of how not to blog. Pashek was a lawyer, or is a lawyer, or was at the time, I should say, a lawyer of 20 years standing. She was an assistant public defender who discussed her cases on a blog entitled The Bard. Now, Bard is spelt B-A-R-D-D. I don't quite know, though, how the acronym then gives you that it apparently stands for Before the Bar, Irreverent Adventures in Life, Law and Indigent Defence. The blog was open to the public, no password protection. About a third of the blog concerned her work and referred to her clients by their first names, a derivative of their first names, or, very obviously, their jail identification number. And the blog contained such examples as this, and I quote, "This stupid kid is taking the rap for his drug-dealing dirtbag of an older brother because he's no snitch. And she swore up and down to me that she was clean. She was no longer addicted. The judge was lenient. And after sentencing, she wanted to see me. So I went back there to see what her concerns were. But I'm on methadone, she tells me. Huh? You want me to go back and tell the judge that you lied to him, you lied to the pre-sentence investigator, you lied to me, and you expect what to happen if you do this? I'll tell you what would happen. The sentence just pronounced would be immediately vacated and you'd go to prison. That's what would happen." Now, they're just two examples of her blogging. I note the decision or judgment having been handed down in the methadone, the sentencing case. Her failure to inform the judge would mean she had not breached our ethical rules about the client having misled the court, because it was after the decision was finally over. But she certainly had breached it with respect to client confidentiality. She also managed to write derogatory remarks about the judges. Unfortunately, none of those seem to have got into any of the reports I've been able to find. Now, it was determined that her conduct constituted misconduct, and she was given what I think was a slap on the wrist, as she was merely suspended from practice for 60 days. The LIV guidelines identify, and I quote, "There's nothing to stop solicitors engaging in general legal debate through social media, but one must be careful not to answer a friend's question, or perhaps an acquaintance or some distance friend, if you're on Facebook or whatever, in a way which may well be seen or considered to be legal advice. As the guidelines identify, that advice may well be acted upon by other friends and not simply the particular individual whose questions you are answering." So you've got to be very careful, again, about what you're putting up. LinkedIn is an example of a social media platform that permits other users to recommend you as having an expertise in some area or areas of law. And it's a social media form that a lot of lawyers, as I'm sure most of you in this room realise, do use. If another member of LinkedIn were to recommend you as having a particular expertise that you did not have, it needs to be removed. It may be, depending upon the circumstances, for example, how long it's been there, that you'd need to amend your own personal profile to make it clear you did not and never had that expertise. Why do I say that? Because it's unethical for you to knowingly hold yourself out as having an expertise which you do not have. If you're on LinkedIn, you need to make sure that something like that doesn't happen. Some forms of social media will allow you to keep your pages, or attempt to keep your pages, private to those to whom you allow access. Now, if they've got such a setting, I say use it, but I'm not sure it's going to be all that good in the long run. You may well recall that last year, 3 federal members of Parliament were called before the Court of Appeal here in Victoria to explain comments they'd made, which had been reported in the press, concerning the sentencing of those convicted of terrorist-related offences by Victorian courts. And in part, the alleged contempt concerned whether the statements attributed to them constituted bringing the court into disrepute. Comments or posts on social media, blogs and the like are similarly subject to the scrutiny of the courts. So again, be careful and make sure that any comments about the administration of justice are tempered and well considered, and cannot be said to be an actual or potential contempt of court, and thus a potential disciplinary problem. Many social media platforms, chat apps, will ask for access to your contact list, your address book, to enable the platform to connect you to people in your contact list via that platform. In reality, what they're trying to do is increase their numbers, the usage numbers, so they can get more advertising dollars. Permitting that to occur may simply mean you're divulging client confidential information, such as a private contact point, private address, telephone number, or more seriously, the actual name of a client, which in general terms is subject to confidentiality, not LPP, but confidentiality. Letting your device use GPS, which again many apps and social media platforms ask you to permit or do automatically. So letting your device to use GPS to identify where you are may disclose inadvertently the identity of a client. LIV guidelines identify the dangers of using social media to breach the no contact rule. And it's a breach of the rule to use social media to make a request to become a friend or similar with another solicitor's clients in order to gain that person's social media input. And similarly, for a solicitor to accept such a request from a person known to be another solicitor's client. Let's go back to America, where this has been a real problem. One example is that two attorneys in America instructed a paralegal to search the Facebook posts of the opposing party. Now, initially, those posts were all public, and there would have been no ethical breach because they're public posts. However, the other party then changed their Facebook settings to restrict public access. And the attorneys then instructed the paralegal to send a friend request without disclosing their identity, the identity or the connection to the attorneys, thus enabling them to breach the access the private account of the other party. It's undoubtedly, without any question, a breach of Rule 33. Twitter. Twitter notably is, depending upon whom you listen to, now the source or correction of all fake news. The use of Twitter may, say for example in a closed court hearing, mean that witnesses learn about the evidence that's been given whilst they're excluded from the proceeding. Again, if you are the lawyer who tweeted such communications, almost certainly you've acted unethically, and you can find your way before the legal professions, the Commissioner for an investigation. The Fair Work Commission in Pearson and Linfox, Australia, has taken the view, and I quote, that in an employment context, the establishment of a social media policy is clearly a legitimate exercise in acting to protect the reputation and security of a business. It serves a useful purpose by making clear to employees what is expected of them. Gone is the time, if it ever existed, where an employee might claim posts on social media are intended, and let me emphasise the next words, for private consumption only. And the Commission went on to say that such a social media policy could not be constrained to an at-work context. So it seems to me sensible and a good idea for social media policies to be implemented by law firms, and will both assist in avoiding ethical breaches by solicitors and in protecting excuse me, the reputation of law practices. And barristers need to think about these things too. The storage cloud is not something that floats around in the sky. It's a digital storage space provided by someone else, and usually for many other users. Your information is only as safe as the technological competence of the providers of the cloud and, or alternatively, other users of that cloud. If you use the cloud, what are the safeguards against being hacked or suffering a cyber attack? Or even your social content being used by others, if you want, if it can be. Now, if you want a demonstration of how insecure social media content is, you only have to think of the reports this week about Facebook and how 50 million Facebook users have had their apparently private data harvested and misused during the 2016 presidential campaign. It's not a matter of saying it's not going to happen to me, it's a matter of saying it can happen to me. You must be proactive, not reactive. We need to understand the limits and pitfalls of technology. We need to be very careful about social media and the likes. And we need to warn clients about the evidence trail that they can leave on social media. They need, I'm sure a lot of clients out there just don't understand, and we need to make sure that they don't create pitfalls and time bombs for us in the conduct of their cases. Now, in that regard, let me just stress this, that in appropriate circumstances, advising them to remove inappropriate material to avoid further problems or aggravating an immediate problem is one thing, but to suggest they attempt to remove all trace or record of the offending material may be likely to fall foul of your duty not to destroy evidence. And in that regard, just remember the so-called document retention policy of British American Tobacco, about which Justice Eames was so critical, and which actually led to an amendment of our Evidence Act. So we do need to warn clients about future posts on social media and the like. Some writers have suggested that professional codes of conduct should contain an ethical duty requiring lawyers to be able to use technology competently in their practices. About 27 American states, following the 2012 amendments to this effect in the American Bar Association's model rules, have imposed such a duty. The Federation of Law Societies of Canada, as at April 2017, was consulting on a change to its model code to include commentary to the general rule on lawyers' competence to include this statement, I quote, to maintain the required level of competence, a lawyer should develop and maintain a facility with technology relevant to the nature and area of the lawyer's practice and responsibilities. A lawyer should understand the benefits and risks associated with relevant technology, recognising the lawyer's duty to protect confidential information. My own view is that ultimately technology is going to lead to such a rule being included in the rules of conduct both for solicitors and barristers. I can't see how it can be avoided. When that's going to occur is up to the regulators, but I suspect it's going to happen in the near future rather than the distant future. And we need to be preparing for that, I think, now. Now, I want to finish my remarks about technology by just talking about two day-to-day terrible practices which I believe do, or may well, constitute breaches of your ethical duties. One is technology-driven, and the other may be cured, or at least ameliorated, by technology. Mobile telephone calls. All too often, I hear members of the profession, barristers and solicitors, talking openly and loudly in public about the affairs of their clients. And all too often, this includes broadcasting what was clearly, or was until the broadcasting occurred, communications which were privileged communications, confidential communications. An example. Whilst walking from the Chambers to the Supreme Court not so long ago, I listened, and when I say I listened because I couldn't block out the sounds, to a solicitor explaining on his mobile, I don't know to whom, exactly the tactics that he was about to adopt in a mediation that was about to occur. He had no concern for the fact that there were 10 or 15 people within easy hearing distance. He paid none of us any attention at all. Any one of them could have been on the other side and finding out exactly the tactics he was going to be using. Go back before the mobile phone. Those telephone conversations occurred in chambers or in solicitors' offices, and the public weren't hearing them. Technology's now got to such a stage with telephones that whereas 10 years ago, frequently when you got in the lift, the phone would drop out, as I'm sure you're all aware. Now, in quite a lot of lifts, depending on coverage, the phone will still be connected to the nearest tower. And I have actually had to stop a colleague carrying on a telephone conversation in a lift because I was on the other side of the case and he was clearly talking about confidential stuff. So just remember, the fact that you can walk around with a phone in your hand doesn't mean you shout. I don't know why most of us do shout when we're on mobile phones. The person at the other end's getting it electronically sent to them. They're not waiting, hoping they can hear you. But anyhow, it happens. So that's one beef that I have, and it's something we all need to think about. I don't think we do, but it's technology causing us problems. Now, the other side of this, as I say, it might be ameliorated by technology. And it's a problem for both sides of the profession. We shouldn't walk around boldly holding up lever arch files, advertising the name of a client or the name of the client and on the other side. Now, it can be argued there's no mischief in that conduct when the files in question are simply part of the material that's being taken to a court or a tribunal, and one can see the names in the daily court lists. Now, I would still prefer, in those circumstances, it didn't happen, simply because bad habits can be created because of that. And bad habits can lead to bad conduct. And the conduct I'm talking about is not just simply files and folders that are going to court. It's something I see constantly when solicitors go to see counsel for advice, or files are delivered for the purpose of obtaining advice. You see somebody in the lifts, and there it is, so-and-so and so-and-so, brief to advise, and it's held up there for all to see. And I mean, you could take a photo with your camera, your phone, if you wanted to. Now, such conduct cannot be condoned on the basis that the client's name may not be subject to legal professional privilege. And in most cases, if not all cases, it won't be. But it's still subject properly to client confidentiality. How's this going to be ameliorated? Well, I'm hoping, and I know a lot of my colleagues at the bar don't want this to happen, but I'm hoping e-briefs will at least lead to a remedial factor happening there. I think that's really all I want to say to you. Can I just close up by saying something very simple, and it's this. Remember, if you don't want your mother, your father, your partner, your employer to see it, read it, or hear it, then keep it to yourself and don't publish it. So thank you very much. I'm happy to take any questions.
Thank you very much, Brind, for a very wide-ranging and insightful discussion on this really most important topic. So let's have some conversation about this. Hands up, anyone who would like to ask a question or make a comment. And do we have roving mics available? So any questions? I'd like to just make one comment in relation to what Brind was talking about in mobile phones. I spent 10 years of my life in the United Kingdom working in the mobile phone industry, and I learned quite a lot about what happens in that space. But one of the things is there's some very, very good psychology studies have been done in the United Kingdom and elsewhere that show that when you're speaking on a mobile phone, you actually focus on the person to whom you're speaking. If you want an example of it, just see people speaking on their mobile phones down the street walking straight at you, and they completely ignore everything around them, including you. So we, the listeners, have to step aside to let them go. And that's part of the problem, I think, that they kind of focus totally on the person to whom they're speaking, forget everything else. And that has to be really, really guarded against. It's, Brind, like can't say how important that is, because it's a clear breach of the duty of confidentiality to allow these kinds of conversations to take place. One quick question for you, Brind. If you were in the lift and you hadn't stopped your colleague from speaking, is there any danger that you might have ended up conflicting yourself out of the case by having heard this information if it was vital and privileged?
I think there's a real problem if I hadn't done that, because I think I then would have become party to information, and it probably would have, given the nature of the conversation that appeared to be happening, I think it would have been very hard for me to divorce myself from that information, and I don't think I would have been confident that I could have taken it and removed it completely. Yes, Jen?
Well, just by way of client confidentiality, when I was president of the bar last year, I got a call from Justice so-and-so to say that he'd just come from the gym and that there was a brief that a barrister had left at the gym, and it was X versus Y and whatnot, and could I please bring that barrister and tell the barrister that this was not appropriate conduct. So you just never know who's there and who's going to say.
Yeah, well, I think, if I can just say this, Jenny's just reinforcing the very problems. We've got to be so careful, and that of course wasn't technology causing the problem, but it just shows you how easy, even in a non-technology sense, it is for us to cause ourselves a problem.
Indeed, there's a question right over on the side. Thank you.
Going back to Dropbox and other cloud storage devices for a moment, I've read some discussion around the ethical difficulties of giving out information to a third party that controls it. Could you comment further about that?
I'm sorry, I just missed part of your question, so I'm sorry.
It's a question about Dropbox and other cloud storage service providers. When we sign up for those cloud service providers, we in effect give control of our confidential information to the provider, so Dropbox for example. Does that have ethical issues for us or legal practice issues for us as barristers and solicitors?
The first answer I'll give you is I've never looked at the terms of agreement with Dropbox. It may be that there's something in there that causes us concern or doesn't cause us concern. So that's the first thing. The second thing is I use Dropbox with my juniors from time to time, but I do not use Dropbox for the purposes of putting anything on it which could be said to be client confidential information. So what we'll do is put relevant cases on Dropbox and that sort of thing, so that you've got a ready access to them. But so far as advices or communications that may reveal strategies, tactics or things like that, I will not use Dropbox, and I don't think anybody here should. Recently I got a phone call from a solicitor about, there's a Chinese chat site, I can't think of its name. Sorry? WeChat. Yeah, WeChat, thank you very much. There have been, and I'm moving away from your question, but I'm just trying to deal with it in a slightly different way. There have been concerns about the security of that chat site, and the solicitor, a young solicitor, wanted to know my views on that. I said, well, if you know that there are security concerns and they're being published, you just don't use it, just remove it. If there's any suggestion, for example, that Dropbox may have access or could have access to confidential information, I use that in the wide term, and that they're not limited in how they could then disseminate that, I just don't think you can use Chatbox. I think it's a breach of your duties.
If I might just add, in relation to the cloud computing issue, it's over 3 months now since I was working at the LIV, but certainly last year 2 of the committees, the Technology Committee and the Ethics Committee, were looking at developing guidelines for use of the cloud by solicitors. So that's something I think that's work in progress at the Institute at the moment. In relation to the guidelines themselves that on social media that Brind mentioned, they arose out of a survey that was done in 2011 by the International Bar Association of all its constituent member societies, law societies around the world. And the question that was put out to them was, do you think you need ethical guidance in the area of social media? 85% of the constituent bodies came back and said yes. When they asked those people, where do you think that advice should come from? Should it come from the IBA in London, or should it come from your local law society? 90% of those said it should come from the local law society. The first law society that put out guidelines, I think it was late 2011 or early 2012, was the Law Society of England and Wales, followed by the Scots 7 months later, followed by us. So the LIV was third cab off the rank in the world at actually putting out ethical guidelines for solicitors in the use of social media, and they were updated again in 2016. So because I was so heavily involved in those, I would reinforce what Brind has said. Those guidelines, only a couple of pages, set up on the LIV website under their ethical guidelines, and I recommend them to you. And I also strongly recommend that you have policies within your offices dealing with the use of social media. The basic rule that staff need to understand is if you want to play on social media, go and play on social media, but don't mix your work in it. That's the real area of real danger.
To what extent can a letter of engagement get past some of those issues with Dropbox and in the cloud solutions?
The problem about a letter of engagement, if it's properly drafted, it's not only going to identify the potential client, but it's all going to identify the potential issue. And that potential issue may not necessarily be litigation. The issue may simply be advice.
I was talking in terms of consent, sorry. The client giving consent to use those forms, so therefore they give consent to the in the sense the outsourcing.
Okay, well, I think in those circumstances there's two things. The first is that the client needs to be made clear that it may be that the use of Dropbox is not necessarily going to protect client privilege. The second is that although the client is permitting you to put documents in Dropbox, you can't waive legal professional privilege or confidentiality. It's only for the client to do it. And the fact that the client says you can put it on Dropbox and you have a real concern about the security of Dropbox and its ability to protect your documents does leave open the potential problem that you are waiving your client's privilege without his consent with respect to the very document you put on. I do understand where you're coming from. My qualification I come back to, as I did before, I've never looked at the terms of Dropbox as terms and conditions. But it's the same with any cloud. I am of great concern, as I said in my comments, the cloud's only as secure as those who are behind it and the other people who are using it. And if you've got somebody who is technologically incompetent as one of the users of it, that may be the way that the hacker gets in, and then you've got problems. And I think we have to be aware of that, and we have to make sure clients are aware of it as much as they possibly can be.
I can use Leap and all that.
I'm sorry, Leap.
Leap, legal software.
Yes.
Solicitor, all that is in cloud. All that information.
I understand that.
You just don't know.
And I know that probably a huge number, particularly of small firms of solicitors, are using a cloud service of some description. That probably comes back to particularly what Michael was saying about the Law Institute developing some guidelines there. But I just think you have to work on the basis and be consciously aware that at the end of the day, all these things are going to be subject to potential cyber threats. We can't ignore it. Years ago, people used to put things in safes. Why? Because they were trying to make them secure from somebody who might break in, who might want to look at it. We need to make sure that we've got some form of secure electronic safe if we're going to use the stuff. It may well be that if you're using Leap, for example, or even Dropbox, the Commissioner is going to take the view that as it's commonly used and the way you're using it was consistent with the way that a member of the profession of good repute would use it, there's no problem. But I still don't think it stops us from worrying about the problem. Yep.
In that situation, if you are using Dropbox, if you have, say, every year technology being checked out by a cyber security expert, would that be a sort of form of protection against any complaint against misuse of confidentiality? So every year you get a cyber security expert to check out the system and say, look, this needs to be done, or this is working properly. Would that be a possible defence before any complaint?
Yeah, I think that's a very good way. Look, I talked about whether there's going to be rules of conduct for technical competence. I think with large firms, the big firms and the medium-sized firms, it's not hard for them to be able to factor in the costs of IT experts to do that sort of thing. For smaller firms, I think you're going to have to use outside experts of the very type that you're talking about to give yourself, like one might audit one's trust account, audit one's electronic holdings. I think that's a very sensible idea.
Can I just make three very brief observations at a basic level? The passwords that we use in our devices is a critical entry point, and so I think we have an obligation to make sure our passwords are as secure as we can make them and to update them regularly. The second part of that is that for mobile devices, laptops and the like, often it's easy to encrypt the hard drive so that if the device is lost, access to the information on the hard drive is not immediately available for someone without a password. And the third thing is certainly for Apple devices, which is what I'm familiar with, you can set up a system where you can remotely wipe the device. And so for phones, iPads, laptops that are liable to be lost, left on aircraft, left on the train, having a method that you can remotely wipe the material, I think is critical.
Well, I will second everything you've just said. I think you're absolutely right, and particularly your comments about Apple devices and the ability to lose it and still wipe it. It's very, very valuable. Perhaps, I don't want to advertise, it's perhaps a very good reason why one should go to an Apple system.
I mean, if there's a lot of literature on this. I mean, the US tends to lead on a lot of these issues. It was leading on social media long before it hit us in the face. The Americans were having to face up to it. And I'm a member of the American Bar Association, so I get a lot of their material coming in now. But if you Google law firm cyber security, you'll get pages of learned articles that have been written on this subject. So if you want to sort of read about this kind of stuff, get on to Google and have a read about it. There's some really good stuff out there. But you remember it was a law firm in the Cayman Islands or wherever that held all that confidential information about all the funds that were held by all the dictators in the world. That was basically a law firm that was hacked, and that just sent that information everywhere around the world. So it's there, it's alive, it's happening to us as we speak. So we just have to be conscious of it. So I think that we've been very grateful to you, Brind, this morning for walking us through the minefield really and showing the pitfalls and giving the warnings, and I think, as you said down there, get regular checks done on your systems, that kind of stuff, go to experts, and hopefully the law societies will start to publish more about it with guidelines. And it's also an issue for regulators as well, but we all have to be very vigilant in this new era. Any other questions? Well, thank you very much for coming, and can we thank Brind again for, I thought it was an excellent talk.